Okay, so chapter 14, we'll talk about property law, or the very basics of property law, mainly related to real property and personal property. We'll not go through protection of the environment. So protection of the environment is also excluded from your final exam. Okay, remember, collective bargaining in chapter 12 is excluded, and protection of the environment is also excluded. We just stick to property law. At any sense, you have the material, you have the textbook, if you have any questions. So let's start property law by differentiating real property from personal property. Real property will be the land, and also anything that is permanently attached to a land. So when a house is built, is the house permanently attached to a land? Yes, it is. Don't overthink. Yes, it is. It's there. You may say that it may be destroyed, taken out, but in principle, it is there for years, for decades. So it is real property. If a swimming pool is built, is this real property? Yes, it is. If a statue is attached in the garden, yes, it's real property. So anything that is permanently attached to the property will also be known as real property, and the land itself. With regards to personal property, well, we have chattels, goods. We saw this in the past. So chattels mean goods, and they are tangible personal property. Tangible meaning we can touch, we can count. So goods, anything that can be weighed and measured. So your pencil, your pen, your water bottle, your smartphone, laptop, backpack, chairs, table, they are all chattels. They are all goods. And then we have chose in action, an intangible right. Chose in action is a right. Well, if you write a check to me, I have a right to that amount. So it's an example of a chosen action. As a shareholder, I have shares. I have a right over a company. Also an example of a chose in action. So majority of the chapter will be spending talking about real property, and then by the end, we'll touch upon some issues on personal property. So real property, land or anything permanently attached to the land. Also, above the land, over the land. Over the land, it's not that it will prohibit an airplane to fly from your property. No, it's not this. But if you have rights over your land in a way that if a neighbor has a tree and the tree branches are over your property, you have a right. You have a right to demand the trees or the branches to be cut. Okay? Or lines, if they have a cord, something going through, you have a right over it. Mineral rights, such as, let's say, gold, oil, they belong to the government, and there's a different body of legislation. So if there's oil under your property, you will be probably compensated for the value of the property, not the oil, and then you'll probably be removed from that property. Different from the US. In the US, some states like Texas, California, if you find oil in your property, it's yours. You can explore it, you can sell it, etc. Here in Canada, it's not like this. Belongs to the government. Now, states in land. How is this? Okay, so this all starts with the king in the very past in the feudal system. So states in land means that the land belongs to the country, belongs to the government. All land belongs to the government. In the past, belonged to the king. And then people, the servants, they would have some rights over the land based on what they gave to the king. This system or this rationale is similar to nowadays. But nowadays, we say that the crown or the government, they own all land in the country, and we are given rights over some lands. So those rights, they are known as states, states in land. So we have the state of fee simple, we have the life state, and we have the lease states. Those are the main states we have in Canada. And I'll go through each of them. So fee simple is similar to ownership. When we own the land, when we own the house. But I say similar because, again, at the end of the day, I don't own anything. I have rights over it. It is the government that owns everything. Okay, but it's similar as ownership. So fee simple, you can use, you can build, you can sell, you can rent, you have all rights over the property. The limitations will be only related to zoning bylaws or the title itself. Eventually in your land, you can only build up to 5 stories or 10 stories. Or you cannot build for commercial use, only for residential use. So those are limitations that may be placed. But other than this, you can do anything with the land. Okay, it's yours. That's the fee simple. So that's why I wrote here, fee simple is ownership. But again, remember, it is the government that owns, we have rights over it. Life state. Life state can only be placed in a fee simple. So I have a fee simple, it's mine, the land is mine, but now I want to put a life state for my mom on the property. If my mom has a life state, it means my mom can have the property, not as the owner, but my mom can use the property, can rent the property. My mom has to pay taxes, has to maintain the property for the duration of her life. After my mom passes away, possession of that land gets back to me. So instead of transferring the fee simple to my mom, I have a life state to my mom in the property. Why do I use the life state instead of a fee simple? The ownership remains mine. When my mom passes away, I don't need, or that property will not be split with my siblings because it's mine. And I've given my mom full use of the property while she was alive. While my mom has the life state, can I sell the property to others? Can I transfer the fee simple to others? Yes, I can. But the buyer, they will have to respect, to comply with the life state. Why would someone buy a property with a life state? You buy a property you cannot use now. Why would you buy a property you cannot use now? Could be investment purposes. You have money available to invest. You believe the property will have good value in the future. You don't need to use it now. The life tenant is paying the taxes, is maintaining. You're just investing for the future. You could do this. Are we good? So that's how it works. Life state. Now, leasehold states. So leasehold states could be a property that is leased, like tenancy, but could also be property common in Vancouver West End, close to UBC. Could be lands that belong to the First Nations. They are reserved. They cannot be sold. They cannot be transferred, but you can live on them for a certain period under a lease date. So there are many properties that are leased for 99 years. They are cheaper. When you buy them, they are cheaper than a fee simple. Yes, because you don't have the fee simple. You have the right to live there, but you do not have property of the land. After 99 years, this will be either renewed or you have to return, but that's the leasehold state. If a tenancy is over than 3 years, it has to be registered. in the title of the property. Title of the property is the document that has all details of a land, of a property. Okay, so that's the leasehold. Leasehold, again, will be either tenancy, could be residential tenancy, could be commercial tenancy, or will be this leasehold state for a longer tenancy in reserve, in land that cannot be transferred. Or even if the land can be transferred. Let's say I own this land. I have a fee simple of this land. And I have a lot of money. I'm a wealthy person. So I build this all and I place a leasehold. And I offer the leasehold for sale. The leasehold, the rights of a leasehold is for sale. I still keep the fee simple. Some condos, some townhouse complexes or apartment complexes, some developers, they decide to keep the fee simple for whatever reasons, and they place a leasehold. Okay. So those are states in land. Those are rights in land. So when you buy your house, that nice house in West Vancouver, $15 million, you'd better have it a fee simple. So you have the full rights over the land. You are a millionaire. Life estate for the benefit of someone during their lifetime. And the leasehold is the right to live for a certain amount of time. We're going to see more details of leasehold moving on. There are other types of interest. Two of them I'll mention to you: right of way and license. I'll start with license. License is, do you know Metropolis Metrotown close by? When you enter Metropolis Metrotown, do you need to have authorization? Do you need to ask for authorization? No, because the shopping center, the mall, they have an implied license. We, belonging to the public, we have a right to enter the place. We have an implied license. But remember, I told you before, in tort law, if we don't behave well, they may revoke our license and they may ask us to leave. Okay, so that's an example of a license. So we have permission to use to enter the land, like in a shopping mall. Right of way is the right to cross someone else's land. This is common in beach houses or farms. So let's say there's a farm over there, and for me to have access to my farm, I need to go through someone else's farm. So this farm belonging to someone else has a right of way. I have a right to cross this property. I cannot park, I cannot build. They cannot park, they cannot prevent me from crossing. So there's a right of way. Again, if you are buying a farm, for example, and you don't want anyone crossing your property, you need to review the certificate of title of the property to assess, to learn if there are any rights of way or not. There are rights of way also under the land for utility companies. They have a right to pass cables, fiber optics, tubing. This is also right of way. So when you see a certificate of title, you will see those right of ways, those as we call lesser interests in the land. Okay, municipalities, sometimes they have a right of way because of electricity, etc. All right, restrictive covenants. Well, we've seen this a lot. Now for real estate, restrictive covenants, they have to be negative. So negative meaning, as a developer, I have a restriction in the land that the land cannot be used for commercial purposes or cannot be used for that. But this restriction has to be negative. And the restriction in the land will bind all subsequent buyers. Will bind everyone. Okay. Why would I have a restriction for commercial? Well, let's say I'm a developer of a new area and I want to have families living And I want to advertise for those families that there will never be commercial establishments around. So it will be a family, community, etc., etc. So I may place this restrictive covenant in the land. Now, when we own property with someone else, well, when we own property with someone else, the general rule is that we own as tenants in common. As tenants in common, each one own their own part. So let me use here the table as an example. So let's say we have this land. Those two tables, they represent the land. My wife and I own this land as tenants in common. It means that my wife owns this part and I own this part. When any of us passes away, our part will go to their heirs. So when I pass away, my part will go to my heirs. So my wife owns that part, and this part, because I passed away, will go to my children. That's tenants in common. The interests, they are undivided. Okay? Now, joint tenancy is different. Again, the same land, my wife and I, we own this as joint tenants. It means we both own everything. When one passes away, the other has everything. Does it make sense? All right. So, joint tenancy is usually good. There's a tax benefit here. There's cost benefit. So let's say two people, they own as joint tenants, or better, they own as tenants in common. When one passes away, their part will go to their heirs. So there will be taxes to transfer to the heirs. Whereas, what if the heir is only their spouse? If they have no children? So the spouse would inherit everything, but now would have to pay taxes. As joint tenant, the spouse would inherit everything because they own everything. Okay? So that's how it is. Now, based on this explanation, question for you. You can read the alternatives and we'll do this together. See? Maybe. Let's do it together. So husband and wife, they own lot A as joint tenants. When the husband passes away, who will own lot A? The wife. Anyone else? No, only the wife. And lot B, they own lot B as tenants in common. When the husband passes away, who will own lot B? Heirs. Only the heirs? Yep. What about the wife's part? Remember, it's lot B. Yep. Tenants in common. Wife and husband. Husband passes away. The wife owns their part. Only the husband part will go to the heirs. So, lot B, when the husband passes away, who will own lot B? Sorry? Mary and the wife. So the wife is for sure, and Mary because of the will. Mary for sure because it's tenancy in common. So C, Mary will get all of lot B. Is this right? No, it's not all. Because the wife's part in lot B is maintained, is kept. Mary will get her father's interest in lot B. That's right, because of the will. John will get no interest in lot A. Is this right?
Yes.
That's right, because A, you told me before, joint tenancy. So A will be only with the wife. Does it make sense? So this is a good reminder that law may be important in life. I suspect, I'm not sure, I suspect the husband here had the best intention of all. One lot to the son, one lot to the daughter. But the husband didn't know that because he owned one of the lots as joint tenants, his wish, his will would not be applicable. So now the son, John, is left without anything. Even though the husband or his father may have had the best intentions of all.
His wife can change her will when she would have now go deal.
The wife?
If his wife can change her will,
No. The wife can have her own will.
like the Lord is now owns her life.
I don't get what you mean.
Now the Lord A owns by his wife.
Oh, the lot A will be with the wife.
Yeah. So now, but the will says that after he died, that will go to his son.
Okay, this
Yeah.
wish, the will is not applicable because of the joint tenancy.
Yeah. So when his wife died, he will get the Lord A.
Okay, yeah. So when the wife passes away, if there's no will, John and Mary will share lot A. But what if the wife leaves lot A all to a charity? Only to Mary? Or to a third party? So we never know, but that's an option, that would be an option. But do you get what I mean?
Yeah.
There are some things, and I'm not advocating that you have to look for lawyers all the time in your life. No, I'm not doing this, but we need to know the implications of our acts. Because sometimes what we intend to, they will not happen in real life, because the law is different. So I hope you are at least getting those basics in this course, so that you know how to act when things come your way in life. Any questions here? All right. So some other interest in land will be the option agreement. Well, this is just a review. We saw this in chapter 6. Option agreement. Yeah, sorry.
Ask one quick question.
Yeah, sure. Yeah, sure.
Can the children sue the owner for the property that they're entitled to? Do they feel that they're entitled to?
They cannot. They cannot, because the will says one thing that the joint tenancy does not allow. So actually, John has no grounds to sue. John would have grounds to sue if there was a forgery, if there was a false will or something like this. But the intention of the father should have been more diligent. The father should have gotten legal advice. Hey, I have these 2 lots. Here's the copy of the certificate of title. Can you, lawyer, advise me? Because I want to leave half of it to John, half of it to Mary. Then the lawyer would say, hey, then you have to change the way you own lot A. Because as a joint tenant, you cannot. Does it make sense?
Yeah.
But they cannot sue. There are no grounds. Yes, exactly. So John would be probably unhappy with his father, and maybe his father had nothing to do, had the best intentions, but
Maybe
did the wrong thing.
if his wife died first,
Sorry?
if John's wife died first. Or is the wife died first and
Yeah.
husband after.
Yeah, but then we don't know if the wife has a will or not, and what the terms of their will are. So we don't. Okay. All right, so option agreement, remember, we saw in chapter 6, this is when the offer is open. It's open for some time. You pay money for time, not for the real estate. Remember this? That's the option agreement. We saw there. Agreement for sale. Well, this is usually when the developer, the owner of the house, they are financially strong. So they say, hey, you buyer, you can pay to me over 5 years, 10, 20 years, like a mortgage, but it's not a mortgage. So you can pay throughout time. You can live in the house right away because you get possession right away. But I will transfer ownership to you. I will transfer the fee simple to you only after you pay the last installment. So the seller, they are retaining the title as security for this. Does it make sense? So I am a seller, I'm selling to you, you pay me in 10 years, you can leave, you can move in tomorrow if you want, but I own the fee simple. Okay, when you make the last payment 10 years from now, then I transfer the documentation, the title will be transferred to you. You will be the owner. That's the agreement for sale. Now, transfer and registration of interest in land. Well, how is the interest in land registered? When there's a purchase and sale, that agreement of purchase and sale will be registered in the title. If there's a life estate, the life estate will be registered. If there's a leasehold, the leasehold will be registered. There are some provinces, or there were provinces, I think there's still 1 or 2 provinces, that they used to have a registration system in which each transaction throughout history would be kept as a file. So if you want to know who owns the land nowadays, you would need to look at the trail of documents over a certain period, usually 40 years they do. But nowadays, most provinces, and more specifically BC, they have this registration system. Sorry, the land title system, not the registration. The land title system. The land title system is when the government guarantees the title. So there's this certificate of title in which will contain the name of the current owner, the current holder of the fee simple. It will contain whether there's a mortgage or not, whether there are rights of way, licenses, everything that contains in this document, in this title, certificate of title, is regarded as to be accurate and true. If it's ever wrong, if it ever causes damages, losses to someone, the government will compensate. There's a fund that is used to compensate whoever suffers losses based on this. So again, very few provinces still have the registration system in which there will be several documents over history. Nowadays, most provinces, and including BC, there's just one document called the certificate of title. And this certificate of title, whatever is there, is true and accurate because the government is guaranteeing this. Okay, so when there's a purchase of property, there will be a change in the land title certificate, in the certificate title. And in BC, it is also electronic, so you can do it electronically. You don't need to go there. Now, condominium and co-op, cooperatives. So condominium, what is a condominium? A condominium has two different types of ownership. One is the ownership in the unit. The owner owns their unit. And the other is the shared ownership of the shared areas. The gym, the swimming pool, the hallway. They are shared by all unit owners. Because you own your own unit, you can have your unit mortgaged. Right? Because you own your own unit. It is different in a co-op. In a co-op for real property, because there's co-op for businesses, etc. But in a co-op for a real property, whoever lives in a unit does not own the unit. They own a share of everything. And usually, not always, but usually, the co-op is a company. So people who live in the units, they have a share in this company. And they pay a monthly amount for the co-op to be maintained. It is cheaper than a rent, but it's still a high amount, I would say. In a condominium, what you pay what is called the strata fee. The strata fee is the money used to maintain the hallway, the shared areas, the garden, elevator, etc. It's $300, $400, $500, $600, depending on the amenities of the complex. And also in a condominium, there will be bylaws. Bylaws will be this document that gives the owners or people who live, tenants, rights and obligations. You can make noise, you cannot make noise from 11 to 7, for example. So you cannot use the clothing washer, the dryer, you cannot use vacuum cleaner from 11 to 7, 11 p.m. to 7 a.m. Those are bylaws. They are present in a condominium. But the main thing here is, in a condominium, the owner has ownership of their unit. In a co-op, there's no individual ownership for the unit they live. Okay? Question for you. Is A false?
Yeah, A or E.
A or E. So the owner of a condominium, the owner of has a fee simple interest in his unit within the condominium structure. Isn't this true? Actually, when you are in a condominium, you have ownership of the unit you live. And so if I live in a townhome or in an apartment, I have a fee simple, I have ownership of that unit if I am an owner. Okay. E, an owner of a co-op, like the owner of a condominium, has real property interest in the suit. Is this true? Are these comparable? Do you have a interest, a real property interest in a co-op? There's no individual interest in a co-op. So this one is false. An owner of a co-op, they have ownership or they have an interest in everything. They have a small interest in everything. The owner in a condominium will have interest in their unit and share interest in the shared areas. This is good? Yeah.
Can one be like the he owns the real property in common as well as his few inside the building. Like I am involved in a building, in the production of building, right? And I live in it as well.
Yes, you can. You can own the unit. But when you own the unit, you have an interest in the land as well. Because the unit is in the land. If it's not a leasehold state, you have an interest in the unit and in the whole land as a shared interest. Okay. All right, now mortgage. Very briefly saying, what is a mortgage? Well, mortgage is when the bank, the financial institution, gives the fee simple owner or the fee simple holder $500,000, 1 million, 10 million to help buy the property. Why does a financial institution give you so much money? You have a good credit record, okay, but why else?
They earn interest on it.
They will actually have a claim over the title, over the property you are buying. So they will use the property you are buying, the real property, as security, as collateral. If you default payment of the mortgage, they will then get the property to themselves. They will sell, they will recover their losses. So that's why they anticipate, they advance you as this much money. Well, first of all, you prove them that you can afford paying the mortgage, the monthly installments. But on the top of that, if you default, the property itself is their security, is their collateral. Okay? It's usually a good deal. Yes, because they have good protection. But it's not free of troubles, because some owners, they will destroy the property, they will not maintain it properly, and then there will be a decrease in value. It's not free of problems, but yes, it's one of the transactions with the lowest interest rate, because the risk is one of the lowest. Different if I advance you money for you to go to a summer vacation. I only get a promise of repayment, right? So different from a mortgage. That's what a mortgage is, but very briefly saying. Okay? Do you have any questions on mortgage?
And do they refund the down payment?
Yes, because it's your part. Yeah, so you make a down payment of let's say 100,000 and the mortgage is 500,000. So if you default, they will sell the property, and yes, the 100,000 is yours. So it's gonna get back to you. That's your equity. That's your equity of redemption.
What about the other 100,000 that I paid in 2 years?
It's also yours, because except the interest, the fees, but yes, whatever you pay for the principal is yours. So it's called as redemption, right of redemption. So your equity is yours. And I'm saying that the bank, they will go after property, will sell the property, will recover their loss, but there's a process for this. It's not overnight. Okay, they may go to court, or they may have mechanisms in the mortgage agreement. So it varies. It's a bit more complex. But in as an overview, the money is giving you money to buy property. The property is their security. Most people with a mortgage, they will pay the mortgage properly. Can you sell a property that has a mortgage on it? Yes, you can. But the mortgage has to be paid in full. So I am buying your house, and your house has a mortgage, and I also get a mortgage. It's fine. So my bank will use part of the money to pay your bank first. Then what is left will go to you. But yes, you can. Most mortgages will have a penalty. So if you sell the property before a certain time, you have to pay a penalty, etc. But you can, because the house, at least you have right over the house. The title is yours. Okay? Those are some words on mortgages. Now, landlord and tenant relationship. So let's talk a little bit about commercial tenancies, not residential, because in residential tenancies, there's more protection for the tenants. Here, what I'll talk to you will be about commercial, will be about leasehold states and also commercial tenancies. Okay. Why commercial tenancies? Why am I emphasizing this? Because in a commercial tenancy, it is supposed, it is expected that both parties are sophisticated clients. Both parties have legal advice, etc. So the law does not protect the tenant much. It is different in a residential tenancy. Now, a residential tenancy, the tenant is more protected. So, what is this? What is a leasehold state? Well, it is when the owner of a property, they give possession of that property to someone else, tenant. And the tenant will pay some money in exchange of possession of the property. Possession of the property may be for some time, maybe for 1 month, maybe for 1 year, maybe for 10 years, maybe for 99 years. So it may be for a specific period of time, or could also be for, as they call, periodic. Periodic tenancy is a tenancy that renews automatically. So if I have a periodic tenancy, it means that it will renew automatically every month, or every year, or every 10 years. It depends the length of the tenancy. So after the tenancy ends, that possession goes back to the landlord. So the landlord, they have the ownership, the fee simple. In a tenancy, they give possession to the tenant. When the tenancy ends, they get back possession. Okay, that's how it works. So in other words, a leasehold state is having a property or using a property without owning it. It's like when we rent a car. We are using the car, paying for that use, but we don't own the car. So this is for real property. What else? What are rights and obligations of landlords and tenants? Well, the landlord, they must offer the premises ready for occupancy. So if they are renovating, if they are maintaining any construction, they have to finish before the tenancy starts, because the premises, they have to be ready to be used. Also, they have to offer quiet enjoyment. What does quiet enjoyment mean? It means no interference. The landlord cannot interfere. So if you go to a hotel, can the management of the hotel enter your room? Yes, they can. They will enter to clean. They will enter to verify any issues that are happening. If you are inside, yes, they will knock, they will call first, but they can. Because it's not a lease. That is a license. When we rent a room in a hotel, we have a license to be there for a certain time. A lease is different. A tenancy is different. The landlord cannot interfere. If I have rented this room, the landlord cannot enter here. Unless we have agreed first. Yes, the landlord, they can enter here to inspect the property. But not every day, not every week. I have the right to use the property in legal ways as I wish, without the interference of the landlord. Okay? So this is what is known as quiet enjoyment. The landlord, they have no general obligation to repair. Again, this is for commercial tenancy. For residential tenancy is different. For commercial tenancy, I rented this room. The floor is damaged for something. I have to repair. The projector is not working. I have to repair. Unless the repair is more structural, is related to the roof that is falling or stairs, then the landlord has the obligation. Okay. Again, it's different for residential tenancy. The tenant, what are the obligations of the tenant? They have to pay the rent, and they are not responsible for reasonable wear and tear. Well, the floor got dirty by use, not excessive use, but by use, wear and tear. So yes, tenants are not responsible for wear and tear. Remedies. The landlord will be able to sue. Sue under what? Well, sue under breach of contract. We'll be able to sue if rent is overdue. We'll be able to sue for damages for breach. I have rented this room to use for courses, and now I'm using it for any legal activities. This is a breach. I rented for, okay, I'm gonna mix here a little bit. When we rent for residential purposes, we cannot use for business purposes. If this happens, it's also a breach. If I rent and I am not allowed to sub-rent, sublet, if I do so, it's a breach. So those are all remedies that the landlord will have. And the tenant, they will be forced to vacate the property if they have overdue rent or if they have breached the agreement. How are they forced? The landlord, they can change the locks. Or they can go to court for an eviction order. So I haven't paid the rent for this room. Tomorrow when I come to work, the lock is different. It means I was vacated from the property. This is not allowed in residential tenancy. That's why I told you this is for commercial tenancies. Okay, tenants in residential tenancy, they are more protected. All right, so this is known as forfeiture. And before forfeiture, the tenant has to be given an opportunity to pay for the rent. So the landlord will approach the tenant, will say, hey, if you don't pay until tomorrow, I'm going to change the laws. It's tomorrow, tenant hasn't paid, then laws may be changed. Breach, landlord will seize the tenant's property. This is known as distress. Again, I rented this room, I haven't paid for the rent. The landlords, they can seize my chairs, tables, projectors, PC. This is known as distress. This is not possible for residential tenants, but it's possible for commercial. Okay. And we've seen this before, occupiers liability. So liability for any damages, losses caused to occupiers, to visitors, they will be imposed on the tenants, on whoever occupies the property, not the owner. So that's related to commercial tenancies. With regard to residential tenancies, I highly recommend you to log on to this website, the residential branch. They have a lot of information for you to learn. I just want to point out to some. So because tenants in a residential tenancy, they are more protected, there are some restrictions in the law. Restrictions, for example, repair. The landlord, they have to repair everything that is damaged in the property. Your washer is not working, they have to repair. Fridge, whatever it is, even light bulbs, they have to replace. That's how tenants are protected. Security deposits, there's a limit. Do you know what the limit is? Half monthly rent. I know in real life, landlords, they want 1, 2, 3. And because the market is so hot, sometimes people agree. This is not legal advice, but if I wanted a property so badly and I was being asked for 1 month property, I would pay. I would move in, and then I would notify the landlord that he would need to refund me half monthly rent, because that is illegal against the law. But I would first secure the property by giving one, because they would lied to me and they would say, hey, you were not a successful applicant, but maybe because of my deposit was half and not one as they had requested. Rent increase is also controlled by the government. So the government will publish every year the interest for rent increase. Again, this is for residential tenants, protecting the tenants. Okay, there are other things you can read here. Vacate, prohibited, so they cannot change the laws. They have to go to court and sue for overdue rent. They do not have the right of distress. In other words, they cannot seize the tenant's belongings. So tenants in residential tenancies, they are more protected. Are we good so far? Still surviving? Some more minutes here. So personal property. Now let's move to personal property. Chattels, you know, movable things, devices, clothes, even animals. Nowadays, animals are considered chattels. There's a proposal to change, but it's not in effect yet. The government has sent a bill to change the legal classification for animals, but until now, it's a chattel. What is a fixture? Fixture is a chattel that is affixed permanently in a property. So let's say a mirror. A mirror is a chattel, is a good. But if I affix it permanently in a bathroom, it becomes a fixture. And it cannot be removed. Unless if I remove, but then I fix the property. Okay. A trade fixture. Have you ever been to BCAT downtown? There's this huge sign of BCAT on the top of the building. That is an example of a trade fixture. If BCAT is renting that building, when they move away, they can remove the trade fixture. Okay, because it's considered a fixture, even though it's attached in the property.
Household furniture,
Sorry?
couches, tables.
They are chattels. They are not permanently affixed in the property. Okay, unless you have a, let's say, sofa that is built with concrete. Let's say it's a different sofa, it's under concrete, and then there's pillows over it, then that concrete would be there, would be considered a real property. Now, finders keepers. Well, if you find something on the streets, public place, you can keep it. You don't need to return it to the police. You don't need to return it to anyone except the original owner. The original owner always has a right over their own things. If you find something in a private place, if you find something at BCAT, you have to return to BCAT. You cannot keep it. So you found an umbrella, you have to return to security office. If you find an umbrella at Willingdon Street, you can keep it. Unless the original owner comes to you and says, hey, it's mine. And they have proof it's theirs. That's the law finders keepers. Is this clear? Question for you. See, when a person finds a valuable watch in public place, he's entitled to that property over everyone else, except the rightful owner, exactly. So the rightful owner always have a claim over their own belongings. Okay, so no obligation to take to the police, doesn't go to the government. If you find something, but the rightful owner finds out, then they have a right over it. When an employee finds an item on the premises of the employer, the employee is entitled. No. They have to return, they have to give it to their employer because it's private property. You only have a claim to personal property if it is a chosen action. No, it's not related to chosen action, it's related to chattels or goods. C is the right one. Very good. Now the last part, bailment. What is bailment? Bailment is temporary possession. Temporary possession. When do you have temporary possession of something? When you rent? When you rent, not a room, because now we are talking about personal property. So when you rent a car, when you borrow a book from the library, if you are a transportation company, when you are transporting goods belonging to someone else, you have temporary possession. This temporary possession is known as bailment. So you should know who the bailee is and who the bailer is. The bailee is the person or the party that has temporary possession. The bailer is the owner of the goods. So if I take my smartphone to a repair shop, am I the bailer or the bailee? I'm the bailer. And who's the bailee? The repair shop. They have temporary possession. Why is bailment important? It's important for liability. What if my smartphone catches fire, is destroyed over fire at the repair shop over the night? Who's liable? The repair shop. But it didn't belong to them, but they had temporary possession. So that's why it's important. Now, bailment can be for value. So someone will have temporary possession for money, for a benefit, when the goods are being repaired or even transported. When I take my smartphone to the repair shop, I will pay them to repair my smartphone. So that's bailment for money. When FedEx, DHL, Canada Post, when they are being paid to transport my goods, it's also bailment for money. So if they are negligent or if damage is caused to my goods, they are liable. Because they were being paid for the service. The same thing for common carriers. So trucking companies, airlines, they have higher standards of liability because they are being paid specifically for that service. They usually have liability insurance. Now, there's also gratuitous bailment. Gratuitous bailment is when temporary possession is for free. When is it for free? When you do a favor for someone, when someone does a favor to you. Can you keep my smartphone while I go to the washroom? It's for free. You have temporary possession of my smartphone, but for my benefit, for the benefit of the bailer. Or, let's say a pet, a dog. You go to a grocery shop and you cannot enter the grocery shop with the pet, so you ask me to keep your pet. We know that pet is a thing, is a chattel. So yes, it's bailment, gratuitous bailment. But it can be the other way around. It can be that you want to borrow my car from me to use. So you will have temporary possession of my car, I am the owner of the car, but now the benefit is for you, not for me, because you're using my car. So gratuitous bailment can be for the benefit of the bailor, the pet example, or the bailee, the car example, when you want to use my car. Okay. Involuntary bailment. This is when goods are forgotten. If you forget your umbrella here at BCAT, BCAT will have temporary possession of your umbrella in an involuntary way because they didn't want to, but they have it because you forgot the goods. So they become liable for any damages to your goods after they find out, after they learn that you have forgotten the goods there. That's involuntary bailment. Question for you. Which one? B? Okay, so Jane asked her friend Harry to look after her very valuable Stradivarius violin while she was away. Is Jane Baylor or Bailey? Baylor. Harry? Bailey. Is Harry doing a favor to Jane? Or is there money being exchanged? No money. So it's a favor, it's gratuitous. Yes, it's gratuitous. Who's having the benefit? Harry or Jane? Jane. Yes, that's B. B is the right answer. Are we good? All right, so as I said before, we're not covering protection of the environment.